Hello everyone, welcome back. It's Michael here with Offshore Citizen, and it's a beautiful day, so we are filming outside in the backyard, which is great. We're going to talk today about the subject of what are some important clauses that you need to have in asset protection trusts. Okay, so here's basically the idea. I mean, it's not that there are many different ways that you can do a trust. So there's no intrinsic thing that makes a trust a certain type of trust. Trusts are very broad instruments. They're almost like an agreement, right? So you could say, okay, well, what makes a certain type of agreement an agreement? Well, basically, it's not that there is, it's not that it's not an agreement or that you register some different type of agreement. It's just the clauses that are in there. So for example, it would be common to have a non-disclosure agreement or a non-circumvention agreement, but you could have a non-disclosure clause or a non-circumvention clause in some other type of agreement. Okay, so this is an important thing to realize. Now, trusts are the same way, right? So you write up a draft of trust deed, and this is very important. Like, I really recommend, this is probably the #1 place where people go wrong. They'll go and they'll get some generic off the internet type or, $2,000 purchased trust that's not built towards what it is that they specifically need. And there's lots of different, I'm going to do a video on trusts for international tax planning because that can be really valuable. But then you have to start to look at, okay, well, what are the effects in a given country of where the settler is? What are the effects in a different country of where the beneficiaries are? What are the effects in a different country where the trustee is? And this is going to vary country to country. And then what is the case law and how is that going to affect things? So for example, there was, I believe it was an Alaskan asset protection trust that was set up. There was a case involving somebody from Washington State and I can't remember what other state. Maybe there was another place where there's property. Anyway, however, it was mixed up. The bottom line is the court threw out Alaskan trust law when it came time to go to court. The choice of law was not Alaska because basically they said, hey, it has nothing to do with Alaska. So you really want to pay a lot of attention to this. So if you're interested in setting up, either for asset protection, inheritance, or tax planning purposes, some sort of trust, reach out to us and we'll help you go through that. Anyway, that being said, what are some really important things in asset protection trusts in particular? Well, you just have to kind of understand what's going on here. The basic idea is if somebody were to sue you or attack go after your assets in some form or another, the whole idea of putting them into trust is that they basically aren't yours anymore. You may somehow have access to them, maybe you benefit from them, maybe you have some sort of management duty, maybe you have some sort of protector duty, but the bottom line is they're not yours, okay? Very important to realize that. And why is that important? It's important because they can only go after your assets legally, right? If these aren't your assets, it would be like they can't go after the assets of your kids, they can't go after the assets of your parents, they can't go after, the assets of your friends. They can only go after yours if it's your liability, okay? So here we're saying, hey, look, it might be my liability. I may be in a situation where there's an issue, but these have been set aside. And it's very similar in a sense to giving them to a charity or somebody else, right? In order to make that work, you need the trust to be what we call irrevocable, okay? So what does it mean, irrevocable? It means that when you transfer the assets in there, you can't undo the trust, okay? So if I can transfer the stuff in and then I can take it back out again, I can shut the trust down, well then, it's not very easy to argue that that's not mine, right? So this is set up, often there's purposes for this. You'll do it in terms of, say, inheritance. You'll say, hey, I'm going to set up a trust. The idea is it's maybe for my family, but then, later I change my mind. I want to shut that down and I pull it back, okay? So revocable trusts are fine. They have a use in certain cases, but from an asset protection standpoint, you absolutely want the trust to be irrevocable, okay? What's the next thing? Generally, you want some sort of restriction on your control, however it is that you're involved, okay? And so the common things that may show up are you may be a protector, so you may be able to replace the trustee. You may try to retain control over how it is that the trust is managed. In this particular case, you can sometimes, depending on where you are, and you have to work with the trust rules in the particular country that you're dealing with and the particular jurisdiction within that country. Say, for example, in the US, there's a difference between, say, South Dakota trust law and California trust law, okay? So you need to be very aware of how these things play together. This is very important. Now, what you would do is you would say, okay, I either need it that I'm not the one managing this and I don't have the power to replace the trustee, okay? This is a critical thing. Why? Why is this important? Well, because if I can replace the trustee, there is some restrictions on how I can replace the trustee. This is important because a court could say, okay, maybe you're not in control, but you can send a letter of wishes to the trustee and request that they do this. And if they don't do it, well, hey, change the trustee to somebody who will, right? So you don't want to be in that situation. And there's some, trustees are fiduciaries, so they're bound by certain laws. And so you can have you'll maybe say, hey, look, the trustee can't be changed. Let's say it's a Cook Islands trust, then you always have to have a Cook Islands trustee, right? Let's say that was, the terms of the trust. You say, hey, you're allowed to change the trustee so long as you use a Cook Islands trustee, right? That would kind of create one example of a restriction there. What is another piece? Well, you could have it that you have that power, except in the case of a dispute period, okay? Then you would go and you would set up during a dispute period, you would lose those powers, and therefore that would protect the trust. What's another example? Another example is that you simply wouldn't have that power at all, okay? And this brings us to kind of the third thing, which is fairly relevant, which is discretion, all right? So how does discretion work? Discretion is, I could write up the trust such that, for example, let's say I have 3 kids, each kid is getting 30% or 33%, 1/3 of the assets in the trust, okay? Well, if that's the case, then if that kid gets sued, then clearly that 33% of assets is exposed, okay? Maybe it's not exposed immediately, but it could be exposed eventually. And so to address that, you would make it what's called discretionary. You would say, hey, there's discretion on how and when, and there's lots of purposes aside from asset protection that may go into this discretion, but you want to have some discretion that's going to allow those assets to be protected in the event that any party. Now, in order to do that, there's another piece that goes along with it, which is you need to have multiple parties, right? So you may say, hey, listen, because here's an example. Let's say that I'm the only beneficiary of a trust, okay? There's a lawsuit. They say, okay, well, those assets in the trust are really your assets because they're all coming to you, right? Whereas if they're the assets of multiple different parties, well, then the argument is much harder to make. And so, maybe you can restrict when they get it, but who cares? So it depends on what your objectives are. But in a normal situation, you generally want it to be irrevocable. You want to ensure that you don't have power over those assets in the event that a court is over top of you. And even if you don't, is you don't have the power to change the trustee in such a way that would expose the assets to the court. And number 3, you're not in a situation where the discretion, there's a lack of discretion, and so those assets are ultimately going to one place, and that can be intercepted. So I hope that helps. That gives you a little bit of context on setting up asset protection trusts. There's lots to write, and there's lots of nuances to how that gets written, okay? Because one of the things that happens very, very frequently is you'll end up in a place where maybe you can keep the assets from the creditor, but the assets are also kept from you. And so you have to plan how to deal with that. Okay, so lots of different things. And again, it depends on where the risks are, where the assets are, what your situation is, what types of businesses you're involved in, what investments you're making, who it is that you're protecting from, and so on and so forth. So it's all very important stuff to go through and get a proper consultation with. Make sure that it's drafted according to what's going to work in your situation. And so I hope that helps. If this is useful to you, please subscribe to our channel, like the video, reach out to us if you have any questions, if you'd like some assistance with anything to do with international tax strategy, international asset protection, banking, etc., residencies, citizenships. We're happy to help you, and I will see you guys on the next video.